So this is just We the People news, okay? Not attorney, not giving legal advice, all right? Never look straight forward. Always look around you to be able to protect yourself by any means necessary. Especially use your Second Amendment and be armed with knowledge, all right? I'm kind of going through these old videos here and there to show of different ways people have been doing things because they were learning things on their own and actually reading some of the laws. Some had more understanding than others and all this kind of stuff, but you got to give credit where it's due. Most of you guys jump and get attorneys. You got to give people credit where it's due when they actually do their own research and put it into practice. Okay? So, you can laugh at these people all you want, but they're doing something. Meanwhile, some of y'all turn around and go get an attorney. Just saying. Who's the one that's really doing the change and the cause and effect of the change?
One thing I want to take up before we talk about anything more, a while back I appointed standby counsel from the Public Defender's Office. For me, what that means, and I'm going to talk and make sure that's what you want, Mr. Pendergrass. Standby counsel for me means they're in the back of the courtroom on one of the benches. They're there to consult with you if you need it during the trial, but you're not required to do so. They have not prepared the case, but they're a resource for you. Do you wish that to continue?
I never asked for that to begin with, so...
I know. I did it one day when you weren't answering questions. I did that. I'm happy to relieve them, but if you want them, I'll leave them there.
I do not want them.
Okay, so for a second here, now, on my last video when I did this 8 months ago, somebody did bring up to my attention that, no, that's not the law. You can only have 12. Wait a minute. That may be in a civil matter, okay? This is actually a criminal matter. There has to be 12 juries. So before anybody just jumps on there and says, well, no, that's not, no. Yeah, okay. Civil, maybe 6. I still think it should be 12, but there's room for error there. But in a criminal, it's definitely 12. And if they don't let you have 12 in a criminal matter, they're breaking the law. Okay?
Defender's Office was relieved from appearing as standby counsel. I'll unappoint them. Mr. Pendergrass will proceed self-represented in this case. Do you want to take up your motion to limit, Mr. Pendergrass? I've read through that. That was filed on Friday, and I'm happy to have you argue that to me.
Absolutely. Is there an objection to it?
I'll hear from your points, and then I'll ask the state as soon as you argue it.
Well, if there's no objection, then it has to be granted.
Mr. Haley, do you object?
I'm sorry, I'm going to back that up there for a second. I wanted to bring up another deal. There is background sound in there, and I'm sorry when I recorded this, and I cannot find this video, so they probably put it in a different category on their YouTube channel or whatever. Again, when I did that video, I did not hear it where I was at. Apparently, the phone picked it better, and I can hear it. So you're going to have to excuse the noise there for a second, okay? Again, that's my bad. I apologize for it. It is what it is, and I can't find the original video of this.
Absolutely. Is there an objection to it?
I'll hear from your points, and then I'll ask the state as soon as you argue it.
Well, if there's no objection, then it has to be granted.
Mr. Haley, do you object to it?
Your Honor, the state objects.
Go ahead, Mr. Pendergrass.
What are the grounds for objection?
If you'll tell us your argument, we also filed it in insufficient time, so if you'll please give your argument, then I'll have the state address their objection.
Well, the argument is there was no criminal complaint filed, no adjudicated facts, so there's no facts to support any claim of any kind of lawful arrest to begin with. So we have unsubstantiated claims, so truth cannot become fact without evidence, and pursuant to the rules of evidence, you got to have the evidence. So there is no evidence, so the man can't talk about something that doesn't exist. I mean, this is fundamentally and principally here.
Typically, evidence comes into trial through testimony, and so tomorrow there would be evidence. Will you respond to that, please, Mr. Pendergrass?
But what evidence are they going to submit of an adjudicated fact of a lawful arrest? or a lawful investigation?
I don't know what I'll be hearing tomorrow. I'll be hearing it with the jury tomorrow.
That would be the plaintiff's duty there to submit that to me, and there is nothing. I'm stating right now for a fact there was no criminal complaint filed. There's no adjudicated fact. We're well past a year's timeline for any kind of a misdemeanor.
In regard to the traffic related allegations?
Any of them. None of them. Prosecutor never filed anything. There's nothing ever been filed. There's no crime, no nothing.
Okay. Go ahead. Anything else you'd like to say, Mr. Pendergrass?
Well, that it would.
Okay, I'm going to pause there right there. Right. Now, going through this process, right, there's supposed to be a reason to have jurisdiction to proceed forward anyway. Where he's bringing up these points. As right now, they cannot proceed forward because they have no jurisdiction in the matter. Nothing's been brought up. So they're actually violating that right now. And because they have to, in order to proceed forward, they have to be subject matter jurisdiction, personal jurisdiction, in-rem jurisdiction, whatever. Common law jurisdiction, amnesty jurisdiction, but there has to be some form of jurisdiction. And again, he's calling out, what? No complainant. And they're just ignoring everything and saying, hey, we have jurisdiction, we're going to go ahead and proceed forward in this matter, even though there's no complainant. This is so ridiculous, it's sad funny.
Prejudice me, as well as be misleading to the jury, to allow hearsay. Those are the grounds to limit this from being presented. So my request and my demand is that he be limited, the one witness they have, to be limited from speaking anything about any kind of probable cause for what he allegedly pulled me over for, because the prosecutor never filed anything. There's no complaints, no adjudicated fact, and again, we are well past the 1 year mark for any kind of a misdemeanor. Nothing's ever been filed.
Okay. There was a formal complaint charging you with resisting obstructing. That was filed.
Excuse me. Objection. I'm talking about to support a resisting a lawful arrest.
Okay, and most of that we call a secondary charge. There has to be a firstary charge. Where's the firstary charge to proceed forward on the secondary charge as well? Brought to the attention. Where's that probable cause of the firstary charge?
Because resisting a lawful arrest, you have to prove that there was a lawful arrest being made first. So
and see, this is what they do to us all the time. This is the reason why, one of the reasons why, here in Texas, appellate courts are being sued, because everybody's bypassing the law.
The adjudicated fact of a lawful arrest being made first.
I understand your position on that. I understand the point you're making. There was a formal complaint. You said there's no formal complaint filed. I want to simply clarify there was one for this charge, this trial, not for any traffic-related offense, but for the resisting obstructing. There was one filed on November 2nd of 2022. Any additional arguments you want to make, Mr. Pendergrass?
That this is all fraud. It's also fraud upon the court, which it was in my motion to dismiss, which you disregarded. The fact is there's no grand jury indictment here. The state of Idaho cannot be the injured party. They're not a real party in interest. It's a fiction. Okay, where's my accuser? I have the right to face my accuser. This is what is the nature and the cause of action here? Where's the accuser? Is the accuser going to take the stand? That's grounds for dismissal right there. No grand jury indictment. Grounds for dismissal. All these things that are lawfully supposed to be done following due process of law and the law itself hasn't been followed.
And you guys heard me many times, right? Who's a man or woman making a claim? Okay? Bring forth Mr. or Mrs. Houston, or Abilene, or Pecos. All right? And I need them to take the stand under affidavit under penalty of perjury. That's making these claims. Where's the affidavit making these claims?
So we got deprivation of rights, fraud upon the court, the judicial machinery itself. There was no initial appearance. It wasn't taken before a magistrate immediately.
I'm going to stop you because we're dealing with your motion in limine. Those are issues that have already been adjudicated. So I'm referring specifically to your motion in limine only. Anything else in regards to that? You brought up hearsay that wasn't included. You included rules 401, 402, and 403. Nothing under Chapter 8 of the Rules of Evidence. So this is something new you addressed. Anything else in relation to
Rule 901?
You wrote Rule 901.
There's no documented proof.
Particularly to self-authenticating of documents. You did raise that, and I acknowledge that as well. Anything else in relation to your motion that you filed?
Yeah, just reiterating that it's unfair prejudice. It would confuse the issues. It would mislead the jury. And there's no evidence to support any of those facts, that there was anything.
And there lies the problem, right? Juries are not smart enough to actually know the law. So, the judge and the prosecutors or any other attorneys, by trickery of words, mislead the people on the jury because they're unknowledgeable of said cases, of said laws, and said rights. Back in the old days, under Prohibition, the jury drank up all the alcohol and told the judge there is no evidence. Well, no evidence, no crime. Case dismissed. Which enhances part of the reason why we could drink alcohol now, people, is because it was having a hard time getting juries convict people when everybody believed they should have the right to drink.
Thank you very much. Mr. Halen, the state's response.
Your Honor, the state would object to this motion in limine. All the evidence referenced by Mr. Pendergrass it does fall within the relevancy and materiality contemplated within Rules 401, 402, and 403. And all of that will be addressed with the testimony of the officer to be presented tomorrow.
Thank you. Anything else from the state?
Nothing further, Your Honor.
Okay.
We'll go back into why does the evidence have to be wait until in court? They have to have evidence before court.
The court has read through the briefing made by Mr. Pendergrass. I've reviewed Rules 401, 402, 403. 401 is a test for relevant evidence. 402 of Rules of Evidence is general admissibility of relevant evidence. And 403 is excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. 901 that was referenced relates to the... I'm going to make sure I give the exact title of this. It's generally within the authentication rules, but at least authenticating or identifying evidence. In this case, for resisting or obstructing, three important elements have to be proven. One, that a person who was resisted later or obstructed was a law enforcement officer. Two, that a person knew they were a law enforcement officer. And number three, the defendant also knew at the time of the resistance that the officer was attempting to perform some official act or duty. I'm referencing Idaho Code 18705 as well as a multitude of case law from the state of Idaho on that. In the court's perspective, context often matters in a criminal jury trial, especially in matters such as this, where an order from an officer has to be in the performance of some official act or duty. The court finds that a traffic stop leading to this is relevant to discuss whether the officer is performing some official act or duty.
Objection. There's no adjudicated fact of it lawfully.
Sir, stop. It's my turn. I'm ruling now. I understand you disagree.
I'm objecting to your entering facts on the record that are not in evidence.
So far, I have not
There's
heard
no adjudicated facts.
I agree with you. There's been no adjudicated facts. I agree with you. What I've heard is argument.
Right there. He just agreed. This shouldn't even proceed forward. But he is, if you sit and look at his face, the judge's face, he was trying to figure out how to weasel his way through there. Okay? He had his thinking hat on. If you sit and look at his eyebrows, look at him thinking, he was trying to weasel his way through this.
Your argument, your verified filings that were done earlier that indicated you were stopped for a certain reason in traffic, which led to this. And so I find that a traffic stop is relevant to whether the officer performed.
Oh, wait a minute. He finds that it was relative, but there was no facts put in the case as such that it was relative. Again, and this right here now is conflict of interest. He is going for the officer over him. And when there's no facts to actually give the officer standing. In say case, on paperwork we don't read it, but in general, this is what I'm speaking of right now, right? When I'm watching this video, there has not been any evidence from the officer for the first-degree charge. All right, we're still stuck on the secondary charge. What made the stop lawful? And he cannot say what it was lawful. Matter of fact, he just plain out said he agreed with the guy, and they still proceeded forward.
Some official act or duty. An officer's duty includes only the lawful and authorized acts of a public officer. We'll be hearing about those tomorrow. Evidence, I expect evidence will be given at the trial. If it's not, then it'll be right for a motion for judgment or acquittal. I wouldn't state.
Now we're going to pause right there again. Right? Lawful acts. The Constitution. Okay? Code, statutes, rules, and regulation is not law. They're policies of some form. Okay? They have the force of law, but they are not law. Okay?
Rest. In this case, a traffic stop is relevant in the court's opinion to whether the officer was acting as pursuant to his duties and engaged in lawful and authorized acts of a public officer. It gives the jury a basis under which the officer was attempting to perform any alleged duties. It's beyond dispute. I'll quote State v. Hallenbach, 141 Idaho 596, pages 599 through 600, a Court of Appeals decision from 2005. It's beyond dispute that during a traffic stop, an officer has the authority to control the movement of the driver of the stopped vehicle, and they have certain rights and duties that they can perform during that. Also referencing Pennsylvania v. Mims, 434, United States 106, Supreme Court case from United States Supreme Court case from 1977. And there is context that can be given. I understand the point that you've referenced. This is not relevant, but the court finds it's extremely relevant in terms of whether the officer was performing some official act. Rule 403, the court may exclude relevant evidence if its probative value is substantially outweighed by danger of one or more of the following. And you've raised some of these: unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or evidence. The court may, it's discretionary in nature. The test is whether it substantially outweighs, the probative value is substantially outweighed by one of those. And the limited information I have, I find that it's not. Quite frankly, this is your motion, your burden to carry. You haven't given me sufficient basis to carry it. And so I'm finding that under 403, it's proper to give it. Now, the court tomorrow, when we hear evidence, and give a living instruction pursuant to Rule 105, if that is proper. I don't know if it will be until we hear that, and I'm certainly happy to address that with the party if they find limiting the evidence to whether the officer was engaged in the lawful performance of a duty, and that the jury shouldn't consider the nature of whether you were registered, not registered, or something else to that effect. So I'm denying your motion, finding it to be improper in this situation. Most of the things you've addressed as well, grand jury indictments, facing the accuser, other things, deprivation of rights, been addressed previously. The court stands by its decision. You always have appellate rights in regards to that.
Why do we have to go through the appellate? Why don't he do his job now? Right? So, in short, and I'm led to believe and do believe, right? This is actually not a due process, but can't believe I'm doing this again. This is a subject matter area to see if the officer actually gave the courts any subject matter jurisdiction over this man. All right, what is the probable cause? So far he's just saying I have probable cause because the officer said something that nobody read and has never been filed because that's the first area charge. It's been completely ignored.
We are set for trial tomorrow, and I plan to go to trial tomorrow. The trial will begin at 8:15 a.m. We'll take up jury instructions. I will have those for the parties at that time, pre-proof jury instructions, and I'll have post-proof, the instructions that I prepared in anticipation if we make it through to the end of the day. We'll take those up. We'll also discuss jury selection. I typically give the parties 20 minutes each for jury selection.
Now we're going to pause there, right? He has filed enough paperwork and called it all out that there has not been enough evidence to proceed forward. However, this lower form of court, which is called magistrate, not a judge, right, is saying it does. When he's gave enough evidence that this case should have been automatically dismissed. Pacalera, right? Did that attorney, is he operating in hearsay? Just saying. Does that attorney need to be up on a witness stand?
Pursuant to Criminal Rule 24, governed by the court, each side will have 4 peremptory challenges that they can exercise. If the parties in consecutive order waive peremptories, if Mr. Haylett waives the peremptory and then Mr. Pendergrass, or if Mr. Pendergrass waives and then Mr. Haylett, that will be a waiver of any additional peremptories. So if you wish to utilize them, please do so. 4 is the allotted number for peremptories here. This will be a jury of 6 persons.
Objection. Right to trial by juries of 12 men of my peers, without whose unanimous consent cannot be found guilty. That's the law.
This will be 6 jurors tomorrow.
Objection. That's deprivation of the right to a trial by jury.
Understand your request. It's denied.
It's not a request. It's the law. You're not following the law. You're in breach of your oath of office. You're committing felonies, which is treason. So I'm accusing you of committing treason on the stand in open court.
Denied, and I am not.
You don't get to deny that. I'm accusing you.
You can say what you want, Mr. Pendergrass. It doesn't make it true, or factual, or reality. And that is what will be happening tomorrow. Which witnesses does the state intend to call tomorrow?
So, just so you guys know, on this behalf, right, this became a criminal trial. So, therefore, the 12 juries is, in fact, in law, in writing. Okay? So, this magistrate, judge, but he lowered himself into magistrate in this hearing. So, you know, if they went to court the next day, he would be a judge. But today, in this process, he's a magistrate. Okay? I hear that they went to federal court, or he's in the federal court with this case today still. So, he's fighting that in federal court.
Your Honor, the state plans to call Garden City Police Officer Bryden Wiggins.
There's pause right there again, right? Now, that judge has got a bar membership card. That attorney's got a bar membership. They're all working for the state. And there's a police officer getting paid to go up on the stand, which is working for the state. Now, Kirk there is the only man there. Now, there's 3 people that's in conflict of interest against Kirk. Just saying, people. Again, I'm not an attorney. I'm not making legal advice. It's just my opinion. Educational purposes only. See how it comes, right? They're all working for the state against the one man. And that is actually a definition conflict of interest, people.
Is that the only witness?
Yes, Your Honor.
Mr. Pendergrass, who are you calling tomorrow?
I'm not calling anybody.
Very well then. We'll also go over your Fifth Amendment rights regarding whether you can testify or not tomorrow, and so I'll talk about those when the state rests, assuming they rest when we make it that far through the trial. So 8:15 a.m. I'll have jury instructions left on the table for each of the parties, I should say. We'll take up the issue of the jurors and the list that we have. That's available through the jury commission. If not, we will have a courtesy copy that we can give to the parties tomorrow. I'll give that, and then I'll collect those after the fact, those lists again. As I said, my intent is to have the jury come down as soon as we can so that we can start. After we take up those preliminary matters, the jury instructions, the jury list itself, 20 minutes per side, and then we'll exercise peremptories and go straight into evidence, opening statements, I should say, and then evidence. Mr. Haley, I'd ask that you have your witnesses here early, perhaps by 9 o'clock, so that they're available to testify when the time comes, and there's no delay in that.
We're just going to go ahead and end it there. All right. Decent We the People News. Okay. What do you guys think? All right. We never look straight forward. Always look around us, be able to protect ourselves by any means necessary. The court is all has to do with facts and law in writing. Okay? They're going all under presumptions. This judge, I don't know. Didn't see the paperwork. He agreed with clerk a couple times. And yet he still proceeded forward. Where's the evidence to even have a court? This should have been dismissed with prejudice, by the way. If it was an honorable court with clean hands operating in good faith, this should have been dismissed with prejudice, period. However, the state has got superpowers and got sovereign citizen immunity, and these three people are working for the state, so therefore, I got to help my brothers out to convict an innocent man, allegedly. Decent We the People News. Bye, y'all.